today to have and commence our final hearing of this, the 32nd Annual Willem C. VIS International Arbitration Moot. On stage, we have two teams representing two universities, two law schools, for whom it is both the first time for their schools in this position on stage today. We have McGill University from Canada as the claimant. And St Gallen University from Switzerland as respondent. We also have a particularly distinguished panel, and we're very grateful for their contribution today. I'll introduce the co-arbitrators before introducing the chair. To the stage left, as you look at it, we have Benno Kimmelman. Benno is an independent arbitrator with over 40 years of experience resolving international commercial, construction, investor-state disputes, and is a fellow of the Chartered Institute of Arbitrators. He's also a professor of practice at Brooklyn Law School, where he teaches courses on international arbitration, litigation, and he speaks and writes frequently on international dispute resolution topics. Thank you, Benno. To your right, we have Cesar Pereira. Cesar is a partner in Justin Pereira Oliveira and Talmini, Sao Paulo, Brazil. He is a co-head of his firm's infrastructure and arbitration practice. He's a chartered arbitrator and fellow of the Chartered Institute of Arbitrators, and was the first chairperson of the CISG Brazilian branch from 2019 to 22. He works as counsel, arbitrator and legal expert, focusing on large infrastructure projects, regulated industries, public procurement and international sale of goods. He's authored or edited numerous book chapters, articles and books, and holds a doctorate and master's degree from Sao Paulo. Thank you, Cesar. Our chair today is Heidi Merikala-Ter. Heidi is currently the chair of the board of the Arbitration Institute of the Finland Chamber of Commerce. And of course, it's the Finnish rules that we are using in this competition. Heidi is a seasoned legal and business professional with degrees from both law and business, an LLM and an MBA, and with 20 years of experience in business law firms and expert organisations. She's known to have a proven track record of leading organisations and resolving conflicts through a pragmatic, business-minded approach. Thank you, Heidi. Ladies and gentlemen, I pass to the tribunal.
Thank you very much. Welcome to the oral hearing in case arbitrary proceedings with the case number FAI Moot 100 and 2024 between Green Hydro PLC, the claimant, and the Ecuatoriana Rempo Ltd as the respondent. I will begin by noting the participants for this oral hearing. The claimant, Green Hydro PLC, is represented by the counsel Tara Osler and Elora Deering. Welcome. And the respondent, Ecuatoriana Rempo Ltd, is represented by the counsel Dominique Rode and Alexander Stadelman. And my name is Heidi Merikala-Ter. I have the honor of chairing the tribunal. Alongside me, I have distinguished colleagues, Mr. Cesar Pereira on my left, and Mr. Benno Kimmelman on my right side. The tribunal would like to start by asking the counsel whether you have engaged in any settlement discussions or if you would have reached a settlement of any of the issues discussed in this arbitration. I let the claimant to comment first.
Thank you, Madam Presiding Arbitrator. The parties have discussed and agreed on an order of proceedings. Respondent will speak first on the procedural issues in this case, followed by Claimant on the same. Claimant will then speak first on the law applicable to the merits, followed by Respondent on the same. Each speaker shall have 14 minutes, with 1 minute each for rebuttal and surrebuttal.
Thank you, and based on your answer, I understand that no settlement discussion, so settlement has been reached.
No other settlement has been reached, Madam Presiding Arbitrator.
Thank you. And for the respondent, any comments from your side?
Both statements are correct, Madam Presiding Arbitrator.
Thank you very much. So, as I understand, you have agreed on the structure and time allocation among yourselves, as we just heard. And we agree, of course, to your proposal, and we can proceed based on that proposal. We would, however, have one request for you. We have, of course, carefully reviewed all your submissions so far, and I think they have been very good, and we have understood the basic arguments each side has. But then we would have one request regarding the substantive issues. We do not need oral submissions regarding Articles 1 and 2 of the CISG. Those issues have been adequately already addressed in your written submissions. We would prefer that you focus on in your oral submissions Article 3 of the CISG, and then whether there has been any exclusion of the CISG. But otherwise, you are, of course, pleased to proceed as you feel fit for the purpose. Do you have any questions on the tribunal's request? Anything from the claimant?
Counsel for Claimant requests if the tribunal has any opinion on whether we should address Article 10 of the CISG.
Colleagues?
No, you don't need to address Article 10. You can focus on Article 3 specifically. So the issues regarding internationality are not to be discussed.
Any questions from the respondent side?
Not at this moment, Madam Presiding Arbitrator.
Very good. Anything else you wish to address before we start?
Nothing further at this time, Madam Presiding Arbitrator.
If not, then we will proceed, and I will give the floor to Respondent's Counsel. The floor is yours.
Thank you, Madam Presiding Arbitrator. Members of the Tribunal, good afternoon. The parties concluded a contract to build a green hydrogen plant. Claimant breached this contract by disregarding the agreed timeline, which led to the termination of the contract by our client and subsequently to this dispute. Then, claimant breached the agreement again by rushing to arbitration instead of first initiating mediation as was agreed. And even now, in this proceeding, claimant is showing disregard for the rules of evidence by submitting a protected offer into evidence while at the same time objecting to a document that demonstrates its attempt to twist the facts that led to the contract conclusion. In light of this, we will be making two submissions on the procedural aspects. First, that this tribunal should reject the claim because it lacks jurisdiction, or alternatively, because the claim is inadmissible. And second, regarding the admissibility of evidence, that Exhibit C7 should be excluded while Exhibit R3 should be admitted in these proceedings. I will turn to the first submission, namely that the tribunal should reject the claim. We will make two arguments in this regard. First, that the parties agreed that mediation is a mandatory precondition to arbitration, and second, as a consequence, because claimant did not comply with this precondition, this arbitration cannot proceed. Addressing the first issue, the mandatory nature of the mediation provision. According to Article 11.1 of the mediation rules, parties can agree that mediation shall act as a bar to arbitration, meaning that no party can initiate arbitral proceedings before first initiating mediation. And in the present case, the parties came to such an agreement. To demonstrate, I would first like to show the agreement itself, which can be found on page 12 of the case file, if the tribunal would follow me there. Page 12 is the third page of Exhibit C2, the purchase and service agreement signed by the party. at the end of the page, we can see Article 30, the dispute resolution clause between the parties. In the middle of the second line, we can see that the parties agreed that any dispute, and I quote, shall first be submitted to mediation in accordance with the mediation rules of the Finland Chamber of Commerce, end quote. And on the following page, page 13, we can see the second step of this dispute resolution process, which is that any dispute shall be finally resolved by arbitration. This wording indicates a mandatory nature of the agreement, and this is underlined by the understanding that the parties had of this agreement. To show the understanding that the parties had and the intent that the parties had with this clause, I would like to direct the Tribunal's attention to page 31 of the case file. Page 31 is Exhibit R2, an email sent by Mr. Diamond, which is the head negotiator of Claimant, to Mrs. Johanna Ritter, which is the head negotiator of our client. In this email, Mr. Diamond reassured Mrs. Ritter of the understanding that mediation is a mandatory step that must be taken before arbitral proceedings can be initiated. In the third to last line, the sentence beginning with "furthermore," we can see this, and he stated, I quote, "Furthermore, the FAI model mediation clause suggested by us clearly provides that the parties must first try to mediate their dispute before resorting to arbitration," end quote. This indicates the intent of the parties, that mediation is a mandatory precondition and that an arbitration cannot proceed until this precondition has been complied with.
But counsel, what is the effect of non-compliance with what you've described as a mandatory provision? Is it that we are without jurisdiction, period? Is it that we cannot consider and resolve the claim? Or is it some other alternative?
Mr. Arbitrator, the consequence of this is that the arbitration cannot proceed. And this, courts are in agreement. Now, the reason for this, there is variation between the rationale of the courts. It is our submission that this is because this tribunal lacks jurisdiction, which has been held, for example, also by the US Court of Appeals of the 11th Circuit in the case of Cameron Atlantic versus Aquachem International, or also by the Swiss Supreme Court in judgment of 2016. Additionally, it is also consistent case law in the state of Ecuadoriana. However, courts that don't see this as an issue of jurisdiction see it as an issue of admissibility, or rather, the inadmissibility of the claim.
But just so I understand, counsel, what does it mean that we lack jurisdiction? On what basis do you submit that we cannot go forward in this proceeding? Based on what legal basis and what factual basis?
The factual basis to address this first, Mr. Arbitrator, is that the parties agreed that mediation is a mandatory step that must be taken, and in the present case, it has not been taken. And the legal basis to use the rationale of the US Court of Appeals from the judgment I cited is that the arbitration agreement does not have any effect until the condition of the agreement, the first step being mediation, has been complied with. However, also, if it is not seen as an issue of jurisdiction, the consequence, if it is an issue of admissibility, is also that the arbitration cannot proceed. And that is what we submit in this proceeding.
I take it these arguments are alternative.
Indeed, Mr. Arbitrator.
And what's the consequence to the tribunal and to its eventual award if we go down one path as opposed to the other path?
One consequence to address this first, which opposing counsel will most likely rely on, is that if it is considered an issue of admissibility, some courts view it that if mediation is futile, so if it is a completely hopeless exercise from the beginning, then an arbitration can still proceed. However, in the present case, this high threshold is not met. And that is because the parties, while they have met and have tried to a certain degree to find a resolution to this dispute, they have met once on executive level in a meeting that lasted 30 minutes. Now, the main reason why a third party, a neutral mediator, can help in such situations is because it can look for more creative solutions, for alternative solutions that consider the commercial strategies and look past any discrepancies that the parties have had between themselves. And such creative solutions cannot possibly be discussed in only 30 minutes of a meeting. Therefore, in the present case, mediation is not futile, but on the contrary, it could help the parties settle this dispute in a more efficient manner.
Counsel, couldn't Respondent have commenced mediation if you believe the process is so beneficial that having a mediator would make a difference? Couldn't you have commenced the process yourself?
Respondent could have initiated mediation. However, our client has terminated the agreement and therefore was content with the situation that the agreement was terminated. Therefore, Claimant, if it wanted the continuation of the agreement, Claimant would have had to initiate mediation, which was also what our client would have expected in the case of a dispute, as it was part of the parties' agreement. And therefore, as this has not happened, this arbitration cannot move forward. And this brings me to our, if the tribunal, yes.
Yeah, if I may, Counsel, just following up on my colleague's question. If we consider this requirement of mediation as an admissibility issue, and you mentioned the idea of futility, isn't the fact, or at least the allegation, that this termination is linked to a matter of public policy an indication that any mediation would in fact be futile in this case?
Indeed, Mr. Arbitrator, it can be an argument of opposing counsel that mediation is futile in the present case because the government of Equatoriana has put forth that a certain price reduction is necessary for the continuation of the agreement. However, also...
I'm sorry, that was not exactly my point. Including because the issue you're referring to, if I'm not mistaken, is related to a document that is being disputed, right? So my concern was about the issue that possibly the termination has to do with a change in policy in your country regarding green energy or green hydrogen. Is that true or not? And if so, would that be an indication of the futility of mediation?
Mr. Arbitrator, it is true that there has been a change of policy in the state of Equatoriana, and that through this there is less interest in green hydrogen projects. However, our client still has interest in the continuation of this agreement to some degree to safeguard the jobs of the workers at Volta Transformer in Equatoriana. Therefore, while it can play a role in regard to the futility, in the present case, our client is still ready to negotiate and continue this agreement if we are able to find a solution in mediation that would enable the project to still fall within the new policy of the government. Therefore, under these circumstances, continuation is possible and mediation could help to find a solution.
Thank you, Kausel. I might want to still ask about the contract negotiations you had. Being an advocate of mediation, and I really understand the benefits of mediation, what you also addressed a moment ago, but I just want to understand when the parties had the contract negotiations, so what did you discuss about the mediation and the commencement of mediation? And here, keeping in mind that the model clause of the FAI mediation rule still says that commencement of proceedings under the mediation rule shall not prevent any party from commencing arbitration in accordance with the clause below. And I understand that this sentence has been under discussion here as well. So I would like to hear your views on whether this was intentionally left out and what would be the implications if it would have been included in the clause.
Gladly, Madam Presiding Arbitrator. The sentence found in the model mediation clause was omitted in the present case. While we cannot find any concrete information in the case file to why it was omitted, the fact that it was omitted speaks to the intent of the parties that mediation is a first step and that arbitration can only be initiated once mediation has been attempted. Therefore, this omission is a further indicator that the parties had this intent.
do I understand that there were no concrete discussions on this clause or this one sentence in the clause?
No concrete discussions on this one sentence in the clause. The concrete discussions that the parties had were that they should first try to settle amicably, and that mediation is what they chose to establish this in the contract.
But counsel, picking up on that and looking at the model clause that was used minus the certain language that you've just described, I don't see in that language anything that suggests that the mediation provision was a condition precedent to arbitration, nor do I see anything in it that says it's a requirement for the admissibility of any claim. So I'd like you to address that so we can, because we need to differentiate between these two arguments and make a decision about which, if any of them, are applicable.
Indeed, Mr. Arbitrator. And while there is no language in the contract itself that says it is a condition precedent, this is not what is needed. We have, for example, also a case from the English High Court, namely Emirates Trading versus Prime Mineral from the year 2014, where the same wording pair was used as in the present case, shall first for the first step, and finally for the second step. And in that judgment, Judge Thayer held under the same standard that applies under the Equatorianian Civil Code, Article 4 in the present case, that it indicated that mediation should be a condition precedent. And furthermore, what is the primary thing that is important is the party's intent, and this is shown through the negotiations. Now, as I see that my time is about to elapse, may I ask for an additional minute to give a brief overview over our position on the second submission? Thank you. In terms of Exhibit C7, to address this first, this is a without prejudice offer that our client sent to claimant in an effort to settle the dispute. Offer is protected by the without prejudice privilege because it is a genuine attempt to settle this dispute. And as it is protected by this privilege, in the present case, it should be excluded from evidence with the discretion provided to the tribunal in Article 34.1 of the arbitration rules. And to give an overview over our position on Exhibit R3.
Can I just ask you one thing, which won't take away from your time? With respect to C7, is it your position that the privilege that you've stated applies sort of unconditionally? It applies to any use of the document in this proceeding?
Could you clarify, Mr. Arbitrator?
My question really is this. Does your application here for us to recognize and essentially enforce the privilege that you've described, does it apply, is it dependent on how the document may be used in the arbitration, or does it apply to the document categorically?
It applies to the document categorically if it is within the purpose of the without prejudice privilege and if the conditions for it to apply are fulfilled. And the conditions are, as has been held, for example, by the House of Lords in the case of Bradford versus Bingley and Bradford and Bingley versus Rashid in 2006, that it must be a genuine attempt to settle the dispute. And the purpose is that statements that a party made during settlement negotiations should not be used against that party. As both conditions are fulfilled in the present case, and it is within the purpose, this document is protected by the privilege and it should be excluded. If I may ask for an additional 30 seconds then to address our Exhibit R3. Exhibit R3 is an internal email of Claimant, an email written by Mrs. Smith, the in-house counsel of Claimant. To address whether it is protected by legal privilege, as opposing counsel might argue, and we submit it is not, we must choose a national law that applies in the present case to determine if it is protected. The doctrine has submitted the closest connection test in that regard to safeguard parties' expectations, and according to the closest connection test, as Claimant is seated in Mediterraneo, the document is guarded by this national law, and under this national law, in-house counsels are not protected. Therefore, the document should be admitted in these proceedings. This concludes.
I just have a quick question. Are you applying the same standard for both documents in terms of the applicable law in applicable rules?
In terms of the applicable rules, yes, Mr. Arbitrator. The applicable rules only state that the tribunal has discretion To exercise this digression, we submit that the tribunal should look to the IBA rules on the taking of evidence, which are international best practice in that regard. And there, yes, Mr.
If I just
Arbitrator?
make clear, I think my colleague's question really was, are you asking us to apply the same rule to make our determination as to whether or not we will admit or exclude the documents? Meaning the test that we should apply. Are you applying it to both documents?
Well, Mr. Arbitrator, the test in the present case, as it is different privileges, the concrete test is different. With what must be compared between the documents is how we figure out what the test is, so which law applies to this question. For Exhibit C7, the without prejudice privilege has been held to be a principle that applies equally in commercial arbitration, for example, by Professor Klaus-Peter Berger from the University of Köln. However, for legal privilege, there is no such international standard, and therefore we must address that a national law must be used to determine whether it is protected. Thank you.
And may I conclude by just asking that should the claimant agree to stay the proceedings and start mediation, would you still be agreeable to it?
In principle, yes, Madam Presiding Arbitrator. However, it is our submission that the tribunal lacks jurisdiction and the stay would only be possible if this is considered an issue of admissibility. However, if the tribunal considers this that way, as the primary objective is mediation, then yes, we will agree.
Thank you. Then we give the floor to Claimant's Counsel. The floor is yours.
Thank you, Madam Presiding Arbitrator. To briefly reintroduce myself, my name is Tara Osler, and I represent the claimant, Green Hydro plc. I will be making my client's submissions on procedural matters in this case, and my co-counsel, Laura Deering, will later present on the law applicable to the merits. Honourable members of the tribunal, counsel for the respondent would have you believe that this case is about claimant not complying with contractual agreements. In reality, this case is about three things: power, pressure, and a price cut. Claimant wanted to deliver the future of green energy to Equatoriana, whereas respondent cared about its bottom line and fulfilling a political agenda. When the first opportunity arose for respondent to jump ship from this contract, they did so, leaving claimant stranded. Against this backdrop, I will present two submissions on behalf of my client, and I shall mirror the structure of my opposing counsel. Our first submission is that this tribunal does have valid jurisdiction to hear this claim, and that the claim is admissible. Our second submission will concern the two contested pieces of evidence. We first submit that Exhibit C7, the alleged without prejudice offer, should be included in the evidentiary record as it does not rise to the threshold of deserving protection under settlement privilege. We also submit that Exhibit R3 should be excluded from the record, as contrary to my opposing counsel has contended, it should be protected by attorney-client privilege, and it is not sufficiently material to respondents' future submissions in this process to override that privileged protection. To move to our first submission, this tribunal does have valid jurisdiction to hear this claim. My opposing counsel has argued that the non-compliance with the mediation step in the multi-tier dispute resolution clause agreed on by the parties should be considered a bar to the jurisdiction of this tribunal. However, if we look to doctrine, we can see that scholar Jan Paulsen has explained the dichotomy between jurisdiction and admissibility in his Lodestar theorem, in which he states that issues of jurisdiction should concern the tribunal itself and its ability to hear the claim, whereas issues pursuant to admissibility should concern the quality of the claim itself. The complaints made by respondents' counsel go to the quality of the claim itself, that it has been submitted perhaps prematurely, as mediation was not undertaken first.
Counsel, with all due respect to Mr. Paulson, isn't the issue of jurisdiction one as to whether or not there's a condition precedent to arbitration here? And we can't escape that, because there are consequences if we make a mistake.
This is an issue that is not fully decided in the doctrine, as Mr. Arbitrator has pointed out. However, we can also look to the works of writers like Gary Bourne and Maria Stekic, who state that preconditions in contracts between parties should be considered issues of admissibility and not be allowed to rise to the level of barring a tribunal to have jurisdiction to hear the claim. In this case, given that the parties agreed on...
Sorry,
Yes.
to follow up on that, if, as my colleague said, if we make a mistake and if we move forward without having jurisdiction, that can lead to serious consequences. If we stop this proceeding now, you go to mediation and you don't settle, you come back here, you will only have some additional costs to pay. Isn't that a better solution, a safer solution?
On behalf of my client, I would say, no, this is not a better solution for the claimant party. As Mr. Arbitrator has pointed out, the tribunal does have ultimate authority and discretion to decide both its own jurisdiction and the admissibility of the claim. However, I would note it has been found in doctrine by Dr. Christian Boris and Rudolf Hennecke that noncompliance with pre-arbitration steps like mediation should not generally be considered to lead to flawed proceedings in the sense of Article 5.1d of the New York Convention on Arbitral Awards. Therefore, there is an...
But what about the submission that's been made by your colleagues on the other side that the mediation provision is a condition precedent to arbitration? And that seems to me to be a contractual issue, not a doctrinal issue. And so I guess what I'd like to know is, what is the claimant's response to the contractual argument? Is this or is this not a condition precedent?
Our response is that this is not a condition precedent. I will point the tribunal now to page 12 of the case file so that we may take another look at the multi-tier dispute resolution clause in question. As my opposing counsel has raised, the language contained in this clause does appear to obligate the parties to mediate first. It says, shall first be submitted to mediation, shall finally be submitted to arbitration. However, the threshold for creating a mandatory condition precedent is quite high, and this clause does not reach it. First, the parties' intentions were not, as my opposing counsel stated, to create a bar to any arbitration, but rather to establish the possibility of mediation with arbitration only as a last resort. Honorable...
May I just interrupt? So you say that it was not the intention, but did you discuss with the other side what actually the parties' intention in this respect is?
That is correct. There was a discussion between Ms. Ritter and Mr. Damon, as my opposing counsel has pointed to the email in Exhibit R2 on page 31 of your case file. However, my opposing counsel's interpretation of Mr. Damon's statement is not entirely correct. He did say that arbitration would be the last resort, as Ms. Ritter requested. However, the language used here is first not what we see repeated in the multi-tier dispute resolution clause. As well, the sentence that has been discussed that was taken out of the model mediation clause was never discussed between the parties before the signing of the PSA, and as stated in Procedural Order 2, Respondent did not check to see if this clause deviated from the FAI model mediation clause.
Was it your intention to delete it, the sentence? Was it intentionally made?
Yes, it was intentionally deleted. However, it was not deleted so as to create a mandatory step of mediation, but rather to prevent parallel proceedings.
Okay. Then coming back to what you said earlier about that it wouldn't be, I don't have word by word what you said, but it wouldn't make any sense to now then mediate. So basically, I just want to turn you into the provisions of the FAI mediation rules, and which more or less say that, first of all, it's very straightforward to initiate the mediation, and the mediation is commenced on the date the request for mediation is received by the FAI. At the same time, if we then are in the mediation proceedings, so the mediation shall terminate the mediation if, for example, a party requests in writing that the mediation be terminated. So does this not suggest that staying the proceedings to at least initiate mediation would be a rational approach? Are you of that opinion? What's your opinion in this respect?
The opinion of my client is that even with the inclusion of the information in the FAI mediation rules, it still does not create a sufficiently binding condition upon the parties. If we look to the general international case law on this subject, it is largely held that multi-tier dispute resolution clauses and pre-arbitral steps should be held as aspirational unless there is sufficiently clear and explicit language otherwise.
But counsel, I think we heard earlier that there is decisional law in Equatoriana to the effect that mediation clauses that provide for administered mediation are deemed to be conditions precedent to arbitration. So don't we run the risk, if we don't follow that law in this case, of our award being successfully challenged?
You are correct, Mr. Arbitrator, as Ms. Ritter did describe the jurisprudential history of Equatoriana, which of course should be given weight as it is a common law state. However, I would first say that this contract, the multi-tier dispute resolution clause at least, is not necessarily governed by the law of Equatoriana. While that may be the law agreed upon in the main contract, the doctrine of severability states that the law applicable to the arbitration agreement does not necessarily have to be the same. The parties agreed that the seat of this arbitration would be Danubia. Therefore, claimant submits that Danubian law as the seat of arbitration should apply to the procedural matters and disputes in this case. Equatorianian jurisprudence should not be given sufficient weight by this tribunal to sway their decision on the admissibility of this claim.
Well, but assuming for a minute that you're correct about the applicability of Danubian law, and I'm not sure that's correct, but let's assume that's true. Danubia would only be the jurisdiction at which a set-aside proceeding would be filed. An enforcement proceeding, if an award were obtained against the claimant, would probably be filed in the courts in Equatoriana. The jurisdiction for which we know from the record, there is decisional law as to whether or not this is a condition precedent. So as a matter of prudence, as a matter of trying to be careful that our award, when we reach it, will have the maximum chance of being enforceable, shouldn't we defer to that and recognize the mandatory nature of this this provision for mediation and enforce the condition precedent?
I understand your concern, Mr. Arbitrator. It is important to make sure any future award will be bulletproof, so to say. However, the information we have about this jurisprudential history in Equatoriana is based only in the statement from Ms. Ritter, who is not a legal professional, who states only that cases where mediation was a condition in the clause, it was held to be binding on the jurisdiction of the tribunal. However, we submit that this case is likely like no other case found in Equatoriana's jurisprudential history, and that goes to the extreme circumstances between the parties and the futility of any mediation that would occur. I would like to present to the tribunal the case of Cardno Middle East Limited versus the Central Bank of Iraq, which was decided in 2023. I bring this case because it is very much analogous to the case at hand. We had a foreign contractor entering into an agreement with a fully government-owned entity, the Central Bank of Iraq. When their agreement fell apart, the Central Bank of Iraq used its connections within the government to have officers of the claimant party arrested in what was later deemed to be arbitrary detainment by the Human Rights Council. In this case, claimants submitted that their dispute should go directly to arbitration, bypassing mediation, on the basis that the history between the parties would make any mediation futile. In this case, the tribunal found that the futility exception should apply to claimant's request, as no mediation between the parties could come to an amicable resolution because of the behavior displayed by the respondent in that case. Claimant submits that this is the same situation we see between the parties here. Respondent has tried to strong-arm claimant into an agreement that would not be advantageous to my client, and has done so by throwing around the weight of its government connections and making threats that did later come to fruition, as Mr. Damon was arrested on charges that were later completely dropped.
Counsel, when I asked your opposing colleague about the futility of mediation, the answer was that the respondent would still be willing to continue with this project under certain circumstances. In the case that you mentioned from Iraq, was that also there, this type of disposition from the government entity?
In the Cardno case, no. There was not an agreement between the parties. There was no interest between the parties, rather, in continuing the project. However, in the case at hand, we know that the parties have had multiple opportunities to negotiate. Unlike my opposing counsel stated, there were multiple meetings since the termination. Only one was between the highest tier of executives of the parties, but it was not the only meeting. The information discussed in these meetings was later put to paper in the without prejudice offer, in Exhibit C7, which I will turn to shortly. Respondent has held a rigid line requiring a drastic price reduction from claimant to have even the possibility of negotiating the continuation of this contract. In the meeting that Mr. Damon had with Mr. LaCour stated that if Mr. Damon would not agree to this price cut, he would pass on the information that would lead to the raid on Mr. Damon's office. It is clear that they were using this government connection and this supposed information on criminal activity to attempt to strong-arm claimant into an agreement. Seeing as I have reached 13 minutes and 42 seconds, may I request an additional minute 30 from the tribunal to make my evidentiary submissions? Thank you, Madam Presiding Arbitrator. I will now turn to our second submission on the evidence. We are at the correct point to discuss Exhibit C7. If the tribunal would like to join me on page 20 of the case file, we can take a closer look at this alleged without prejudice offer. This offer was sent by respondent to claimant following the meetings that we previously discussed and contains the same information that was discussed by the parties in those meetings. If the tribunal looks to the final paragraph, we can see that Mr. LaCour states that any further discussion between us or our lawyers only makes sense if Green Hydro is willing to accept a price reduction of 15% or at least a two-digit number. Any possible negotiation only makes sense if claimant will accept this drastic price cut from the outset of this process. My opposing counsel has stated that this document should be excluded as it is protected by settlement privilege. However, claimant submits that this document does not rise to the threshold of deserving that privilege protection as it is not a genuine without prejudice offer. Applying the name without prejudice does not make it such. There are certain qualities that must be fulfilled. For example, there is no admission against claimant's interest made in this statement, only the request for a serious admission against interest on the part of claimant.
Just to be clear, do you agree with your opposing counsel's proposition in terms of what law and what rules we should apply to examine these two documents, especially C7 that you're addressing?
In this case on C7, we would submit that whatever law is applicable, the document simply does not rise to any level of settlement privilege. However, if the tribunal would like our opinion on applicable law, we would state that the application of the closest connection test can be used for both documents. The closest connection test in this case would likely lead to Equatorianian law, as it is a project in Equatoriana, with one party being seated in Equatoriana. However, even though there are protections for settlement privilege in Equatoriana, this is not a true, genuine offer for settlement. My opposing counsel has mentioned the case of Bradford v. Rashid from the English House of Lords. However, in this case, it was established that since the party sending the letter was only asking for a concession from their partner and not providing one on their own behalf, it did not constitute a valid without prejudice offer.
I ask that if this C7 would be excluded, so is there any other documents that would replace this in its purpose?
This document is essential for claimant's future submissions as it puts to paper the offers that respondent was making following the termination and demonstrates how important this price cut was to them, as we will submit when this arbitration later goes to the merits, that their reasoning behind terminating the original contract was to secure a price cut.
So is there any other documents, or is this the relevant document here?
This is the most relevant document. However, the witness testimony given, for example, in Exhibit C5 also contains information as this same topic was discussed in the meetings. However, given that this is the official alleged offer that respondent sent, we submit that it is truly material to claimant's future submissions.
Counsel, is this, you made a point that the letter provides for a significant price decrease, but doesn't the letter on page 20 of the record also include the fact that respondent offered you a first demand guarantee for the performance of its obligations under the contract? And as far as I can tell from the record, there was never any guarantee provided for with respect to this contract. So it looks to me like that's something new that's been put on the table, and it's something that would provide value to the claimant. Isn't that true?
What would have provided value to the claimant is continuing the project on the timeline that the parties were both working on originally. Respondent terminated the agreement after a minor delay in the delivery of plans that, as found in Procedural Order 2, would not have substantially impacted the overall timeline. We hold that offering to continue a project which they terminated for their own convenience, which goes against the agreement between the parties, is not an admission against their own interest, as we could have continued the project without this entire dispute. At this time, if the tribunal will allow me an additional 30 seconds to briefly submit on R3. Thank you. Exhibit R3, as submitted by claimant, was an internal email with, as submitted by respondent, apologies, was an internal email with claimant's in-house counsel. My opposing counsel has submitted that it should not be protected by attorney-client privilege, as they find that the law of Mediterraneo should apply. I will first offer a brief correction. There is law in Mediterraneo allowing for the confidentiality of attorney-client privileges. However, it is known to not rise to the threshold of stringency of protection seen in Equatoriana or the United States of America. However, we hold that closest connection test should lead to Equatorianian law applying, as that would also be the most favorable law in this case. This is advising on Equatorianian law on a project taking place in Equatoriana with a business partner seated in Equatoriana. Further to this, we submit that this is not sufficiently material to respondents' future submissions. Two individuals on this email chain, Mr. Damon and Mr. Cavendish, are witnesses in this procedure. If the information included in here is important to respondents' future submissions, they'll have the opportunity to cross-examine and interview these witnesses at a later stage of this process.
Counsel, let me ask you this question. Looking at R3, I note that there is nowhere on this document in small letters or bold letters, capital letters, something that says privileged and confidential attorney-client communication. I don't see it anywhere on that page. Have I missed something?
It does not say privileged in large letters. However, the assumption of the parties was that this would be kept confidential, as that is part of the code of ethics for legal professionals in Danubia.
Well, if that were the case, counsel, then when claimant wrote to the tribunal and asked the tribunal to exclude this document from the record, and that's on pages 34 and 35 of the record, why is it that the only basis for that exclusion was the alleged illegality of the document, and the words attorney-client privilege or privileged communication are not to be found anywhere in that letter?
Our client's initial submission was that it would be excluded because it was potentially obtained illegally. However, we expand our submission now to include the protection of attorney-client privilege. On the issue of illegality, as far as our client knows, this document only came into the possession of respondent following the raid on Mr. Damon's office, which, if you remember, was carried out based on information provided by Mr. LaCour. At no point has any member of the claimant team who was privy to this email shared this document with any other person. Therefore, claimant can only assume that respondent must have obtained it through some unlawful means. Now, typically, the burden of evidence to prove illegality of evidence falls on the party making the accusation. However, several international arbitration tribunals have found that the standard of evidence should shift if prima facie evidence of wrongdoing can be established and there is an adverse presumption of illegality. Respondent has not provided any alternative route through which their client received this letter. Therefore, we submit that based on the existence of the raid and their lack of explanation for how they came into possession of this document establishes prima facie evidence and therefore will shift the burden of proof to prove they obtained it legally onto respondent.
And just a quick follow-up question. You replied to my colleague that you have expanded the objections to this document after your initial application. Can you procedurally do that? Do the FAI rules admit that, or do you have any other basis to be able to expand your objections like that?
We would base our expansion of this submission on the issue of party autonomy, which is a priority in arbitration proceedings. The parties must be able to submit their best cases to the discretion of this tribunal.
But isn't there at some point a cutoff date after which you cannot expand your argumentation?
I will ask my co-counsel to find this information in the FAI rules so that we can be sure to provide the most accurate answer. There is a cutoff date for the answer to the request for arbitration. However,
If I may refer to Article 35 of the FAI rules, which includes a cutoff date. So does that provision has any relevance here?
of course, this provision has relevance here, Madam Presiding Arbitrator, as it does state that there will be a cutoff date for the submission of evidence on the merits, documentation, and new arguments. However, it can allow exceptional circumstances if the tribunal agrees otherwise. If the tribunal will allow, we would submit that these circumstances are exceptional. The submission of this document blindsided my client as they were not aware that respondent could have ever had access to this email. The first submission we made was the argument that first was available to my client. However, if the tribunal is not interested in hearing any arguments other than what is presented in our original request to have this evidence excluded, we will submit again that it was very likely obtained illegally, and that because we have established prima facie evidence through respondents' connections to the prosecution office, as detailed by Mr. LaCour, and their lack of an explanation for how they came into possession otherwise, we established that the burden of proof to prove that this was obtained legally shifts onto respondents' counsel. If there are no further questions from the tribunal, we'll end our submission here.
Thank you very much.
Thank you.
Then I give the floor to Respondents' Counsel.
Thank you, Madam Presiding Arbitrator. Opposing counsel has stated that this dispute is about, I quote, power, pressure, and a price cut, end quote. And yes, it is. It is about the power of this tribunal to hear the claim, which it doesn't because of claimant's pressure tactic of rushing to arbitration. And on top of that, claimant submitted the protected offer our client sent to resolve this dispute into evidence. So yes, the dispute is about power, pressure, and a price cut, just not how opposing counsel portrayed it. Thank you.
Thank you. Please, the floor is yours.
Thank you, Madam Presiding Arbitrator. My opposing counsel has stated that the pressure in this dispute is claimant rushing the arbitral proceedings. However, we will once again point out that respondent has used its connections within the government to initiate an investigation that led to the arrest and detainment of members of the claimant party. Respondent is in the position to put pressure on claimant here, a medium-sized engineering firm entering into a new market in Equatoriana. We ask that the tribunal remember here the power imbalance between the parties when they are understanding where pressure has been applied. Thank you.
Thank you very much. Are the counsel ready to move to the merits part of the case? And keeping in mind the directions from the tribunal in the beginning, so I give the floor to Claimant's counsel. The floor is yours.
Honorable members of the tribunal, thank you. My name is Alora Deering, and I appear on behalf of Claimant today, Green Hydro PLC. I will be discussing why the CISG is the law applicable to the merits of this case. Respondent signed this international agreement with Claimant because Respondent could not find a local partner who was acceptable to contract with. And then the winds of politics changed and Respondent terminated their agreement. Now, Respondent is trying to use its power to pressure a price cut on Claimant. Citing an insignificant delay, Respondent alleges that the CISG does not apply because they do not want to prove fundamental breach under the CISG at the second stage of this arbitration. But the CISG does apply for two principal reasons. Firstly, this contract is governed under the CISG and is within its scope. And secondly, the parties did not validly exclude the CISG from their agreement. Now, keeping in mind the tribunal's direction, I will pass the point on internationality as the tribunal has our written submissions, and if the CISG applies, it will also need to be international. Moving on to the second point, which is the sale of goods under the CISG. Claimant does not contest that this is a mixed contract. Clearly it is. There's provision of services and also provision of goods. This tribunal, under Article 3, subsection 2 of the CISG, must determine whether services are preponderant, and if they are, this will be excluded under 3.2. But they are not. Here, my opposing counsel may refer to the fact that there is mention of a turnkey nature, turnkey contract. This is seen in the request for quotation. Claimant was aware of this when they signed up. However, turnkey contracts are not automatically excluded under Section 3.2, and this we reference the Advisory Council, opinion number 4 on mixed contracts.
Isn't it the contract law of Equatoriana a more appropriate set of rules when it applies to turnkey contracts?
So the contract law of Equatoriana is not necessarily the law which governs this agreement, and I can speak to that point. If we turn to page 12 of the case file.
But just to follow up on what the presiding arbitrator asked, can't the tribunal determine the most appropriate law to this case and consider the fact that the Equatoriana law, which is the UNIDROIT principles, right, expressly deal with turnkey contracts, unlike the CISG? Can we take that into consideration?
The tribunal does have that discretion, but it is claimant's submission that that would not be what the parties had agreed to at the signing of the contract in this case. The CISG does govern mixed contracts, and this is clear from the inclusion of Article 3.2, and it governs mixed contracts which are for the sale of goods, even if they have some service elements. Turnkey contracts have both elements. But we'll see in Article 29 on page 12 of the case file the governing law which the parties agreed to at the time the contract was formed. If the tribunal is with me, this article states, the agreement is governed by the law of Equatoriana to the exclusion of its conflict of laws principles. Now, the law of Equatoriana includes the CISG, and this is because Equatoriana is a contracting state of the CISG. There's ample case law to suggest that a reference simply to the law of Equatoriana includes the CISG.
Did the parties have any discussions in this respect?
Parties did have discussions in this respect. So I will, before getting back to my sale of goods argument, we'll turn to the perhaps implicit exclusion argument my opposing counsel may raise. Now, my opposing counsel may suggest that the meetings between, or has suggested that the meetings between the CEOs have been important. And indeed, there were meetings between the CEOs which brought up the CISG. Claimant's CEO, Mr. Cavendish, mentioned that the CISG was the gold standard in his mind, and so Respondent's CEO could not have been unaware of Claimant's intent to apply the CISG in this case.
And has it been applied before in similar relationships?
It has, not in exactly the same relationship, as this is the first time the claimant is contracting with Respondent. However, claimant has previously contracted with other government entities in Equatoriana under a similar but slightly different model contract where the CISG was applied.
Was it explicitly stated in the provision?
I will turn to that provision now. So in the drafting history of prior to these parties, but in the drafting history that claimant was aware of, there was a change in the model contract. This model contract was the basis for the parties' purchase and service agreement, and it had a change in the governing law clause. Now, there was also an official press release made as to why this change was made. And the press release stated that the change was made, and I quote on page 53, paragraph 10. If you'd like to follow me, I'll quote once you have it. This choice of law change was made to strengthen the role of Equatorianian law and Equatoriana as a place of dispute resolution. Now, formerly they had referred explicitly to the CISG, but again, this change was made before the current nationalist government came into being. It was made to strengthen Equatoriana as a place of dispute resolution. The CISG is a harmonization tool which is used to resolve disputes internationally. If the government, the former government of Equatoriana, wished to strengthen Equatoriana as a place of dispute resolution, it follows that they would also strengthen the CISG within the law of Equatoriana to do that. And so here, in the press release, we do see the intention that was clear between the parties as an intention to strengthen the role of the CISG alongside the law of Equatoriana. And so this is the model contract that was underlying the parties' purchase and service agreement. So while the wording may have changed, perhaps it was more efficient to just clearly state the law of Equatoriana as Equatoriana is a contracting state, and there's no need to refer to the CISG in that case.
But
My
counsel,
colleague had a question. Here,
Yeah,
Mr. Bennett.
sorry, go ahead, please.
but counsel, looking at on page 53, paragraph 10 that you took us to, tell me if this is correct. The old language in the model clause was, the agreement is governed by the CISG, period. For all issues not regulated by the CISG, the law of Equatoriana shall apply, period, close quote. So the original language had both the CISG and Equatoriana law in the contract. And as you said, there was a press release made by the government as to why the change was being made. And the change was essentially to drop the CISG from the sentence and leave just Equatoriana law. And the purpose was to strengthen Equatorianan law. So isn't it also possible to interpret this legislative history, in effect, that there was a deliberate elimination of the CISG in favor of Equatoriana law based on the changes in the words that were incorporated in the form contract?
And before you answer that, I think it transitions into what I was going to say. When you deal with governments, you know there are regulations, there are standards, there are uniform model contracts like the one we are dealing with here, and there is this history of a sequence of model contracts. As my colleague was saying, shouldn't we be aware of the meaning that the old model contract assigned to laws of Equatoriana, and the fact that that meaning was not explicitly changed in the new model contract?
So I would submit that while it's possible to answer both questions at once, to see it the way Mr. Presiding Arbitrator on my left sees it, it's possible, but it's not the most realistic or accessible interpretation. So while the former was regulated by the law of the regulated by the CISG, and then the law of Equatoriana shall apply if this is not the case, we see that the law of Equatoriana has a place below the CISG in the application hierarchy. Now, if we strengthen the Equatorianian law, we possibly bring it up to the level of the CISG. We're still strengthening the law of Equatoriana, but we're not taking away the strength of the CISG, and my interpretation then would also consider the second half of the sentence, which states that Equatoriana as a place of dispute resolution is also to be strengthened. And so while we need to take into account the history and the words that were used, we also need to take into account the second half of the sentence. And so the interpretation that Mr. Presiding Arbitrator has suggested is possible. It doesn't explain the second half of the sentence as well.
How do you suggest that we interpret and understand the second half of the sentence?
So the second half of the sentence, I would suggest, ensures that the CISG remains strong in Equatorianian law, and while then Equatorianian law also is brought to the same standard. So again, in the parties' contract with this history, it was clear that the law of Equatoriana shall apply, but the law of the CISG also applies for things that are governed under the CISG. So I will turn now to whether this contract is governed by the CISG, because that is also essential. Now, I had mentioned turnkey contracts. I had mentioned that these are not always excluded, and this per the Advisory Council Opinion number 4, which suggests that turnkey contracts must be analyzed on a case-by-case basis. Now, there are two general tests that are used to analyze the preponderant part under Article 3.2.
Also, before you go into 3.2, even following some numerical order.
Yes.
I would like you to address 3.1.
Okay.
Isn't 3.1 a reasonable ground for us to consider that the CISG is excluded in this case?
3.1, I will read it out, states that contracts for the supply of goods to be manufactured or produced are to be considered sales unless the party who orders the goods undertakes to supply a substantial part of the materials necessary. And so in this case, respondent has not undertaken to supply a substantial part of the materials. And
But if you look at the contract, isn't there a pretty substantial list of obligations that the respondent has undertaken, including to provide the place for the construction of the plant and other items? Would that fall under 3.1?
there may be services which respondent has undertaken, and this you're accurate in referring to Article 4 of the Purchase and Service Agreement. But land, for example, is not a good, as goods under the CISG are movable and tangible, and land is not movable. Now, the goods in this contract are not the things that respondent has provided. And for this, I would turn the tribunal to page 17 of the case file. And this is in the witness statement of Mr. Poole Cavendish, claimant's CEO. We'll be looking at paragraph 11, the table under there. Here we see that the highlighted parts in this table are for the sale of goods, and this has been shared between the parties in the witness statement of Ms. Ritter, respondent's head of contracting. She has confirmed that she's seen this table, and she agrees that what is in Mr. Cavendish's witness statement is correct. And so here we see that the goods under this contract are the core system for 100 million, the transformer and electrical equipment for 40 million, and an additional 50 million.
But let me just point out that Article 3.1 does not mention goods. It says, undertakes to supply a substantial part of the materials necessary for such manufacture or production. Does that make a difference?
So for this, we would turn to page 29 of the case file, and this is Ms. Ritter's witness statement. Again, respondent's head of contracting. If I may request an additional minute and a half from the tribunal to address the question.
Yes, please do.
Here we see at the bottom of paragraph 4, the last sentence on the third line from the bottom, which states, according to my recollection, the highlighted parts in the internal calculation contained in Mr. Cavendish's witness statement were the parts relevant for fulfilling the local content requirement as to the delivery of materials. And so here, she indicates the delivery of materials is what the highlighted parts in the table were. It's not clear from the case file that there were any other delivery of materials, and so this tribunal should consider, even under 3.1, that all the materials were the same as the goods in this table on page 17. Given that there's 63% for the sale of goods or the provision of materials, as Ms. Ritter refers to them, this would be economically preponderant for the sale of goods. Now, my opposing counsel may suggest that the parties' intentions differed. However, respondent under the government has been pursuing a green hydrogen strategy to achieve their net zero goal and is thus very interested in the efficiency of the plant. Claimant's technology has achieved an 85% efficiency in the production of hydrogen, and respondent contracted with claimant precisely to achieve this efficiency. Now we know later respondent contracted another plant with the alkaline technology, a different technology, but that was not this contract. This contract was with the PEM electrolyzers, was for the sale of those goods, and so under the preponderant test, this tribunal should also find the parties' intentions were for the sale of goods. With this, unless the tribunal has further questions,
I might say that before you go to Article 3.2, which I expect you to do next, so just if you can address then whether there is a difference between the substantial in Article 3.1 and then the preponderant in Article 3.2.
there is a difference because the words are different, perhaps, but again, under Article 3.1, the materials necessary, we have no indication in the case file that respondent is being seen as providing any materials. I would invite my opposing counsel to counteract this, but again, the substantial part here would be provided by claimant. And then,
Did you have a question?
No, I think we can go.
I just have, well, you, of course, you, because of our questions, you discussed the exclusion beforehand, but I would just like to confirm with you, in a government contract that is awarded through a competitive process like this one, is the standard for excluding the CISG the same as in a private contract negotiated between two parties, or is there a difference? Is there a different standard that we should take into consideration to acknowledge an implicit exclusion of the CISG in a government contract like this one, or not?
it's possible there is a different standard. However, that's not the case before this tribunal. And for that, I would point to page 52, paragraph 3 of Procedural Order Number 2. And here we see in the first part of the answer, respondent is a separate legal entity of private law. They are not the government. They have close ties to the government, but they are not the government. And so it's submitted that the normal private standard should be the standard this tribunal applies.
But does it make a difference that the government has to treat all bidders equally, that this is a competitive process, public tender? Does it make a difference or not, regardless of whether the entity is a private law entity belonging to a government or the government itself? The contracting process, like this one, does that make a difference in terms of the standard for the exclusion, implied exclusion of the CISG?
Again, if it was the government contracting, perhaps it would make a difference, but here it's not. It is respondent who is contracting to fulfill the government's goals, but not necessarily on behalf of the government. And so in this case, the standard should be the same standard as applied in private law. Now, to briefly conclude on Article 3, subsection 2, we have again the economic value test, which I have suggested is preponderantly for the sale of goods, as 63% of the plant was for the sale of goods. And then the parties' intentions also were to contract for innovative technology. The electrolyzer stacks is the key good under this contract, which respondent contracted with claimant to procure. So then this agreement is not preponderantly for the provision of services and should not have the CISG excluded on that basis. Thank you.
Thank you very much. Then I give the floor to Respondents' Counsel, please.
Thank you, Madam Presiding Arbitrator. Members of this tribunal, good afternoon. Opposing counsel stated that respondent would, and I quote, try to use its power to pressure claimant, end quote, by denying the application of the CISG. This will not be our submission today. Our submission will simply be that the party's choice of Equatorianian law was towards the Equatorianian Civil Code and not the CISG. And we will show this based on two submissions, following opposing counsel submissions and the directions given by the tribunal. First, that the CISG does not apply, and second, that even if it did apply in principle, that the parties validly excluded it. Beginning with the first submission, again reiterating that for the internationality and the sale by auction, Article 2, letter B, CISG, that we will be referring to our written submissions and focusing on the argument regarding the sale of goods. We agree and we will focus on the fact that Article 3, paragraph 2 of the CISG precludes the possibility of the CISG applying in this case to the parties' agreement, because it is preponderantly a labor and service agreement. And to be precise, it is a turnkey contract, not just as opposing counsel stated because the parties called it so in the request for quotation, for example, but because it fits the definition. Claimant was contracted to construct a completed hydrogen plant, where respondent should have been able to turn the key and produce hydrogen. And specifically for turnkey contracts, the CISG Advisory Council holds that, for one, there are opinions of authors that generally the CISG cannot apply to turnkey agreements, but indeed that a case-by-case analysis is needed. But before we begin with the case-by-case analysis, I would like to rectify one factual matter. Opposing counsel has stated that Ms. Joanna Ritter, the respondent's head negotiator, has verified the veracity of the table contained in page 17 of the case file. That is not so. I believe opposing counsel, what meant by this was the passage in Joanna Ritter's witness statement, if I may direct the tribunal's attention to there on page 29, Respondent's Exhibit R1, in paragraph 4, line 8. And I will quote, "According to the internal calculation he had shown me, as correctly stated by Mr. Cavendish in his witness statement, the idea was that up to 80% of the works and deliveries for the e-ammonia option would be provided by P2G," end quote. What Joanna Ritter meant was, yes, she was shown the table, and this is not disputed, but Joanna Ritter has not verified the contents of this table. The contents of this table come from one party, claimant, and cannot be verified by either the respondent or the tribunal. And having established this factual matter, I would like to turn to the actual test of Article 3, Paragraph 2 of the CISG. For one, yes, there are two separate tests, the economic value test and the essential criterion test. It is our submission that, as the CISG Advisory Council Opinion number 4 states, that when the economic value test is impossible or inappropriate, then the essential criterion test comes to play. And to show...
Before you go into that, I would just like to clarify something here. You mentioned that the preponderant part would have to be under 3.2, labor or other services. Where exactly do you find labor or other services in the contract as the preponderant part? Can we really equate non-sale to labor or other services? Or is labor or other services something that is more specific than simply not sale of goods?
It is our submission, Mr. Arbitrator, that this can be found in the agreement. For example, if I may direct the tribunal's attention, in fact, to page 8 of the case file, which is not the parties' agreement, but is the request for quotation, which Article 30 of the agreement holds that the agreement can be interpreted in light of. Now, on page 8, which states what the actual request for quotation was for at the very top, and I quote, "the engineering, planning, construction, and delivery of a planned turnkey." And this, Mr. Arbitrator, is our submission that these elements, the engineering, the planning, the construction, do constitute labor and service elements in this case. So yes, what is not a good in this case is considered to be labor and services and therefore precludes the preponderance of sale of goods. But to return to the essentiality criterion and to underline the fact that in this case the economic value test cannot apply, I would like to direct the tribunal to a recent case in this manner in front of a tribunal constituted from the Santiago Arbitration and Mediation Center in the year 2023, referred to as the Interrau v. Selig case. The facts of the matter in that case were very similar to the facts here. For one, it was also a turnkey agreement concerning the construction of a hydroelectric power plant. But for the other, in that case as well, the tribunal was confronted with numbers provided by one party. But the tribunal held that specifically for turnkey agreements, these numbers cannot be taken at face value because they cannot be verified. And because of this, the tribunal held that the economic value test was inherently inapplicable to this turnkey agreement and applied the essential criterion test, which tests where the parties' primary interests lay. And to pick up on the parties' primary interests in this very case, opposing counsel raised that, yes, there was a novel technology involved, and this was claimant's primary interest. But the interest in this agreement wasn't to deliver electrolyzers with this novel technology. Claimant has been doing this for years. It is claimant's primary interest for the very first time to actually showcase this novel technology in a large-scale 100 megawatt green hydrogen plant. Therefore, claimant's primary interest, which was also underlined, in fact, by claimant's CEO in a statement to the press, was towards the construction of a large-scale plant and therefore towards labor and service elements. Turning to respondent's primary interest, yes, opposing counsel is right. Respondent's primary interest here was not the technology of claimant, because there were other technologies available to Respondent, for example, the alkaline electrolyzers, but more rather the actual plant itself. Respondent was not interested in the delivery of some electrolyzers or a transformer. Respondent is an energy company and was interested in the energy storage provided by hydrogen, and therefore Respondent's interest was a completed hydrogen plant, again showing a preponderance of labor and services. But even if the tribunal were to hold that the economic value test applies, this does not change the result in this case. For one, also a very similar case law to the facts at hand would be the case 2017 case in front of the German Federal Court of Justice, referred to as the potato chips plant case. Now in this case, the court was confronted also with a turnkey agreement regarding the construction of a plant. And the court held that to speak towards the actual intent of the parties, which is also assessed under the economic value test according to the CISG Advisory Council opinion number 4 raised by opposing counsel, that the actual obligations of the contractor must be evaluated. In fact, the court stated that if the obligations of a contractor in a turnkey agreement go beyond simple delivery and installation, that the contract cannot fall under the CISG. And this is again the case here, because Claimant was not contracted by Respondent to simply deliver and install a plant. This was a complex process, adding to the fact that this was a novel technology never before used in a plant. Claimant had to engineer and plan and construct this plant as is reflected in the request for quotation I have shown the tribunal before. And in fact, adding to that, Claimant was supposed to provide additional maintenance and training services for the span of 1 year after the construction of a plant. And all these facts, under the rationale of the German Federal Court of Justice, show that, again, even under the economic value test, there cannot be a preponderance for the sale of goods in this case. And therefore, with this precondition for the CISG applying not being given, the CISG cannot apply, which would bring me to our second submission, which is the only other reason, which is an alternative reason, that even if the tribunal were to find that the CISG applies in this case, that the parties validly excluded it nonetheless. Article 6 of the CISG provides the possibility to parties to exclude the CISG, and the intent of these parties is evaluated under Article 8 of the CISG, which provides the possibility to also take, for example, the drafting history and negotiations of the parties into account. In fact, this is also held by the CISG Advisory Council opinion number 16 on this topic, regarding that an implicit exclusion of the CISG is indeed possible. And this will be our submission today in this matter, that the part...
Just interrupt. So why should we rely on an implied exclusion if the parties could have expressly excluded the CISG?
While the parties could have expressly excluded the CISG in this case, they did not. They simply stated a choice of law for equatorial law. And this is unclear if this provides for one for the CISG.
Picking up on that, that's unclear. That's what you said. Your client, as the government contractor or the government party in this case, had absolute control over the language of the contract, correct? There was a previous model contract. This is the new model contract. Shouldn't we apply contra proferentum approach to the lack of clarity in that language, if that's the point that you're making?
I'll answer twofold, Mr. Arbitrator. For one, no, the tribunal should not apply the contra proferentum rule. For one, because Respondent was not the author of this model clause, Respondent's government was. The parties simply agreed to use this model contract as a basis.
Sorry, Counsel, but your client is a part of the government when it alleges a public policy, a government policy, as grounds for termination of the contract, right? Correct? Can you say that for the purposes of the contract, your client is not a part of the government, therefore it's not responsible for the subsequent drafts of model contracts? Is that consistent?
It is consistent insofar the question is where the government actually exercises its influence. In the case of that the political interest may shift away from green hydrogen, then yes, there is governmental influence, and this must be taken into account, because after all, Claimant did contract with a governmental entity. But in this instance, it was not governmental influence to use the model contract, but the party's choice. But regarding the law of Equatoriana used here...
Do you have any grounds to say that the parties could have chosen not to use the model contract?
It was a proposal made by the head negotiator of Respondent, Joanna Ritter, which is stated in her witness statement and which was accepted by Claimant. So yes, it was a discussion between the parties to that effect. And regarding the choice of law of Equatorianian law, to bring more light into this choice of law, I would like to, as was already raised by the tribunal, to shed light onto the actual drafting history of this clause. And to do this, I would like to direct the tribunal's attention to page 53 of the case file on paragraph 10 of procedural order number 2. I'm aware that the tribunal has already looked at the clause. I would, however, like to raise 2 points to this. If I may quote the clause itself, "The agreement is governed by the CISG. For all issues not regulated by the CISG, the law of Equatoriana shall apply." End quote. 2 things are demonstrated with this prior choice of law. And being mindful of my time, if I may ask for an additional minute to quickly.
Yes, please.
Thank you. For one, that the CISG was stricken from the choice of law clause. But for the other, what the actual interpretation of the term law of Equatoriana was. Because in the prior choice of law clause, law of Equatoriana referred to everything but the CISG, or the non-harmonized law of Equatoriana. And turning to the actual intent behind this change of the model clause from Respondent's government, this was not for nothing. If we follow opposing counsel's logic, then this clause would have been changed for nothing by the Justice Department, but that is not so. The press release gave 2 reasons, because there were 2 clauses changed. The choice of law clause, the reason being to strengthen the law of Equatoriana, again, meaning the non-harmonized law of Equatoriana, and the forum selection clause, which is why strengthening Equatoriana as a place of dispute resolution. And indeed, Claimant was aware of these 2 changes, because to the forum selection clause, Claimant was opposed and proposed its own forum selection clause. But to the choice of law clause, deleting the CISG and showing law of Equatoriana as something not meaning the CISG, Claimant made no comment. It did reference to the CISG in regards to prior contracts as a gold standard. But this makes the point even stronger, because if it truly was held to be a gold standard, why not comment on this change? Claimant.
Did your client ask for any comment, or did you discuss it more?
Our client, if I may answer your question, thank you. Our client did not ask, but it was clear to our client that this choice of law change was evident to Claimant itself. But what was also, for example, speaks to the intent within Claimant itself was, for example, Claimant's head of legal conducted legal research on the merits of the case. And to the actual consequences under the CISG, she assigned her legal intern. One does not assign a legal intern if one truly believes that the law applicable was the CISG. And this, again, shows the intent of Claimant to actually exclude the CISG. Thank you.
Counsel, as you know, the CISG directs us to take into consideration all the circumstances, right? And we have here one circumstance, which is that in the former model contract, the parties expressly made a reference to the CISG, so they knew they could opt into the CISG. The second circumstance is that your client or the government that owns your client had control over the language of the contract. In the third circumstance is that, as you may agree, the standard interpretation of a clause that provides for the application of a contracting state law means that the CISG is included in that national law. Considering all those circumstances, doesn't it make much more sense for us to consider that the new model contract was simply cleaning up the language of that provision and saying what generally is said when parties want to not exclude the CISG by making a reference to the law of a contracting state? Isn't that an easier interpretation of what the parties did instead of assuming an implied exclusion?
It may be an easier interpretation, Mr. Arbitrator, but it would not be the correct one. Because as you stated, if we look at all these circumstances alone and separated from one another, yes, then that could be perhaps so. But looking at the whole picture, this drafting history, this awareness of claimant of the drafting history, the deletion of the CISG by a Justice Department which does not change a clause for no reason, then this shows an extent to exclude, both from the respondent side, but also from claimant side, from their internal expectations within the department.
Thank you. Do you have any further to add?
No, thank you, Madam Presiding Arbitrator.
Thank you very much. Then I give the floor to Claimant for a short rebuttal.
Thank you. Honorable members of the tribunal, 1 point on rebuttal. Opposing counsel has raised the cases Inter Rao and the potato chips plant case, but these are both distinguishable from the present case. In Inter Rao, the claimant had an obligation to go back and forth and work with other contractors and build the hydroelectric plant in layers. Such is not the case here. Respondent has an obligation to hand over infrastructure already to which claimant's PEM electrolyzers will quickly be plugged in. And so both under Inter Rao and the potato chips plant case, we do not see necessarily the same true turnkey nature, and so this agreement is still governed by the CISG. Thank you.
Thank you very much. Then the respondent, please.
To use opposing counsel's word, one does not plug in a 100 megawatt hydrogen plant. Yes, respondent provided the land the plant was built on and the connections to the electricity network and the gas network, but the actual construction of the plant, which is the core issue of the Inter Rao v. Selec as well as the potato chips plant case, do not change anything as to the facts at hand and to the rationale of these both courts, which should be considered by the tribunal. Thank you.
Thank you very much. We are now approaching the end of this oral hearing. And on behalf of the tribunal, I would like to ask the council whether you consider that you have been treated equality in this case, with equality in this case, and whether you have had the opportunity to present your case in accordance with the Article 26.2 of the FAI rules. Claimant?
Yes to both questions, Madam Presiding Arbitrator.
And from the respondent side?
Indeed, Madam Presiding Arbitrator.
Thank you very much. Then the tribunal now declares the proceedings closed regarding the matters to be now decided by the tribunal pursuant to Article 41 of the FAI rules. According to Article 41.2 of the FAI rules, after the closing of the proceedings, no further claims, arguments, or evidence may be presented by the parties regarding these matters to be decided today. Then it remains for me to thank the council, the parties, and my co-arbitrators for the good proceedings. Thank you very much.
And ladies and gentlemen, I think that round of applause said it, but on behalf of everyone here, thank you to everyone for what a wonderful moot it was. Ladies and gentlemen, we now move to the banquet stage of our proceedings, but we need your assistance. We need you to leave promptly. Please do not leave anything with you. Please make sure you cannot reserve tables. Please make sure you only come back in through the doors to my right, stage left, my right. We're only going to use those one doors to come back in. You can leave by any of the doors, but we will limit the doors that are coming back in. You must have your ticket. It is a ticketed event. Please also know